Excellencies, ladies and gentlemen, it's a real honor for me to be able to talk to you today on an issue which I, on purpose, took a little bit provocative. Is the law of the sea applicable to the Arctic? Question mark. What I will do is I'll try shortly to give you the reason why this topic came into my mind, and I must admit that it was rather recently that I stumbled upon the topic which I would be addressing you today. I'm trying to get this forward, yes. After having given the background of this question, we'll then go into the detail. Is the Law of the Sea Convention indeed applicable to the Arctic? And we'll say a little bit about the Law of the Sea in general and the Convention more in particularly. And then, secondly, we'll talk about whether it's going to the Arctic and how is its relationship with the Arctic. Depending then on the answer to that question, whether it is or it is not, then the impact of that question is analyzed shortly. And finally, we'll try to arrive at some conclusions. But first of all, let me clarify why I gave you this very provocative title. This inspiration came recently, and it was only beginning of this week that we were still in St. Petersburg, where there was a conference on a workshop on Arctic shipping organized by the Norwegian University Center. This had to do with an invitation by the University of Tromsø, which is now also called the University or the Arctic University of Norway, where they had several projects going. And the first one was an ALEX project, where they tried, with respect to law as well, have some clarifications as to the shipping in the Arctic. And more recently, and that's even more important, I think, they were able to obtain substantial funding at this university for law of the sea, for the establishment of a Law of the Sea Center. And so it was within that framework that we were there, talked about navigation in the Arctic, and where the statement was made by a Russian colleague that the Law of the Sea Convention is not applicable to the Arctic. And from there, my question mark. First of all, the Law of the Sea. The Law of the Sea is a topic or a subject of international law which has been codified. And this is, of course, makes it easy on lawyers because you have a document that you simply have to apply. And to be honest to the United Nations very often is blamed for everything and nothing. But here, with respect to the Law of the Sea, they have been very instrumental in achieving codification. Because this is one of the successes. They were able to codify the Law of the Sea not once, but twice. And the first time they did so in 1958, the first United Nations Conference on the Law of the Sea. And the third one came up with a totally new document, which today is considered to be the basic rules governing the law of the sea. It's an important document, many signatures, but more important of it today, a lot of ratifications, as you can see, 165 states and the European Union. This is quite a lot for a convention which is not reciprocal. If you look at other conventions, of course, you have conventions which have been covered by many more states or ratified by many more states, like the Convention on the Child. But then again, here we have a very uneven interest of different states. You have, of course, states with a long coastal coastline, and then you have states like mine, Belgium, which only has a coastline of 64 kilometers. And of course, the issues are on a totally different level. This number has given inspiration to some to call this document the Constitution of the Oceans, and that's really what it is. Now the question then is, how does this apply to the Arctic? The reasons why the person in question was of the opinion that it did not apply to the Arctic was that the travaux préparatoires, he said, clearly indicate that the Arctic and the Antarctic are excluded or were excluded from the negotiations which lasted from 1973 until 1982. The Antarctic Treaty, you can make an argument of that because, of course, it had been regulated by an international system of treaties. But nevertheless, it doesn't mean that within the Antarctic Circle, the Law of the Sea is applicable in the sense that if there's no sovereignty, at least the regime of the high seas will apply. But what with respect to the Arctic? There was only one treaty which was in operation between the 5 Arctic states at the time that the negotiations started, because it was the same year, 1973, and that was the Polar Bear Treaty. So it was not really a very substantial legal system applicable. A remarkable argument for several reasons. First of all, travaux préparatoires. As we know, the first conference, of course, was prepared by the International Law Commission, but the second one was not. And so it means that we do not really have any travaux préparatoires unless we're talking about the official documents which were released after the 17 volumes. But they only contain very general statements at the beginning of the conference and maybe in the Commission's statements by official statements by the different participants. But what happened very often was negotiations behind closed doors, and we don't have any record of all that. So it means that to rely on travaux préparatoires for the Third United Nations Conference on the Law of the Sea, it's like of an anti-thema, I think. Nevertheless, with respect to Article 234, which is the only article on ice-covered areas which could relate to the Arctic, of course, if you look at the travaux préparatoires there, it's very clear where it comes from, because this has been negotiated by the 3 important countries, or countries with a direct interest in the issue, and that were Canada, the US, and at the time the Soviet Union. How do we know? Well, as you can read from the submittal of the President of the United States, it was Clinton at the time, when he put the International Convention on the Law of the Sea before the Senate, he argued that with respect to Article 234, that's exactly what it was. It was to make more legal what Canada had done before, and that was the enactment of the Arctic Waters Pollution Prevention Act of 1970. So certainly Article 234 is not there to regulate areas like the Baltic, where of course you also have ice-infested areas, but it was clearly focused on the Arctic. Also, when you look at the statement that the US made within the official documents, they said that in their opinion, the extended continental shelf was also applicable to the Chukchi Plateau. And if you know that this one extends in the Arctic, it was clear that the US had very much in view that this convention would also apply to the Arctic. And of course, nobody at the time contested this position of the United States. The other argument then was, well, if you look carefully at the Ilulissat Declaration, you will see that the Law of the Sea Convention is not mentioned. And this is quite true. The Law of the Sea Convention is not mentioned, but the international lawyers amongst us, I mean, very well realize that if you have one party that is not a party to an international document, of course you don't cite that document because it means that it would not be applicable to this particular party. And as we all know, and I think some other speakers will talk about that, the United States still is not a party to the United Nations Convention on the Law of the Sea. So if it applies, then what is the effect of it? Well, I think the normal zoning applies like it does anywhere else. And it means that you have all the normal maritime zones that you have, like territorial seas, contiguous zones, EEZs, continental shelves, extended continental shelves. The question then is, do you also have what is called the area? And this is a more tricky question. Theoretically, there is no reason why the area should not be there. But the question is, if you give or grant all the states surrounding the Arctic the extended continental shelf that they seem to be claiming, it might well be that there is not much area left. But this is a totally different issue, and I think, again, other people here will address this issue. So in theory, certainly there is an area. Then also the normal rules from where you start measuring all these maritime zones apply. And that means that the convention is very clear that normally you have the low water line which applies, and if the low water line, if you are confronted with a coast which is deeply indented, or you have a lot of islands in front of it, then you can make use of the straight baselines. And as you can see on the map, most of these times this baseline very much follows the general direction of the coast and must follow the general direction of the coast. Unfortunately, even though these rules are all specified in the convention, their application sometimes gives rise to difficulty. But that is not because the rules are not applicable, but simply because the application might not be that straightforward. Of course, there are straight baselines in the Arctic. Canada has established them in '85, and also Russia established them around the same period of time. And the question is whether they comply with the requirements of the convention. Sector lines, previous speakers have shown the sector line on the map. What is their impact from an international law point of view? Might be more questionable, but we have seen that in the delimitation agreement between Russia and Norway, suddenly one of the parties pretended that the sector line should be applied, and finally a middle line has been agreed upon. So it means that at least the sector line was taken for that purpose, given some weight. And then also the historic seas, and I will conclude, historic seas, also there we'll see that whether you can have that, it's quite a delicate issue, because the convention only talks about historic bays and also other historic tidal. Conclusions. The Constitution of the Ocean, this does not mean that this is the only document that can be applied. The Convention certainly allowed for regional documents also to be applied, so what the Arctic Council has been doing, I think, very much fits into this framework. And my last line is, constitutions can be flexible or can be rigid. The United States Constitution is a good example of a rigid constitution, 1776, and it's still there with a few amendments. If I take the constitution of my own country as an example, it's a very flexible one. We only exist since 1830, and it has changed so many times that following constitutional law in my country, it's very daring to do that. So the question is, what kind of constitutions do we have for the oceans? Well, I can assure you that it's a very flexible one, because it has been changed already substantially a few times, twice, and there are attempts for the moment even to change it even further. And so there is no reason why, if the Arctic tomorrow becomes very important, why maybe there should not be something on the Arctic as well. I thank you for your attention.
Thank you.